So this morning, I am going to be bringing you many interviews, hopefully, because there are many angles to what is fast developing into a constitutional crisis for Ghana. We have a speaker who has declared 4 parliamentary seats vacant because 4 members of parliament have had their status changed by deciding to either go independent or to run on a political party's ticket. And the speaker on Thursday invoked Article 97 of the Constitution and standing orders to declare their seats vacant. The majority leader went to the Supreme Court ex parte. That means that the other side was not aware. This is on Friday. And secured what is called an interlocutory stay of execution, or stay of execution, if you like, stay of execution of the speaker's ruling. Now, there are many angles to this. Now, one school of thought is that the speaker is bound by the ruling of the Supreme Court because Parliament makes laws. The judiciary interprets the law. And so the judiciary, in granting that stay of execution, essentially have bound Parliament to that judgment. And that if the speaker refuses to comply with the judiciary's judgment, it would amount to a contempt of the Supreme Court. Okay. Now, the other view is that you cannot have one arm of government, like the judiciary, impose its will on another arm, which is the legislature, because there's something called parliamentary autonomy. And in as much as the judiciary can hold somebody to contempt, the legislature can also hold somebody in contempt of Parliament. So, and again, some people feel that you don't have, you only have a stay of execution of a court order, and that a ruling of a Speaker of Parliament is not a court order. So you do not have it doesn't make sense to them for that type of stay of execution to be granted. So this morning, we are trying to work our way around the legal labyrinths of this particular issue within the confines of a constitutional democracy like Ghana. The Constitution is the supreme law of the land. But how do we interpret it to make sense of a very murky situation? By the way, this parliament has had a very troubled history. Even the first day of it coming into life was marred in a lot of controversy, where one side went to sit at another side. There was almost fisticuffs. Even the election of the speaker itself was marred in controversy, with blows being exchanged. The military had to come in. Some people said that was an attack on our democracy. We've gone through all of this. Now, this is their last, I don't want to call it sitting, or their last leg of whatever they do. And now we have this very serious interpose. How do we resolve it? How do we ensure that this parliament does not, or this situation does not result in a breakdown of our democracy completely? Because, by the way, our democracy is if you like, it's based on our constitution, which grants which spells out 3 arms: the executive, the president and his cabinet, and ministers, and the appointees of the government who have executive power. Then the legislature, who make laws, the representatives of the people, 275 of them. Then the judiciary, who are appointed by a combination of the executive and the legislature through an approval process. So now that the judiciary is saying that the speaker's ruling should be stayed, is the speaker bound to abide by the Supreme Court's ruling? Or can he say, you judiciary, you are in contempt of us because you are trying to interfere in what to do? Because, by the way, there are provisions around some level of immunity for MPs where, in fact, if you want to arrest an MP, or if you want an MP to attend upon a court, the speaker has to give permission. So that also elevates the speaker to a certain position. All right. And we also have this whole ranking: the president, the vice, the speaker, the CJ. They are the top 4. So is it in order of precedence in terms of who is more powerful? And the other point we need to remember is that in the past few months, there have been many instances of judiciary, legislative interaction. So, for example, in the matter of the LGBTQ plus, there's a court case now that is trying to prevent the speaker from transmitting the law to the president. All right, that matter has not been fully heard. Then, even prior to that, there were some issues in Parliament which had to go to Supreme Court. The issue of 136, 137. So this Parliament has been characterized by controversy requiring some judicial intervention at some point. But is this the last straw? I want to take your comment on that. Too many times in your view, right? That it seems as if this particular Parliament has had to resort to court.
Yeah.
Either side has had to resort to court for too many times. And you think it's a problem for the for the democracy or for the Parliament?
I think so, because in this matter, in my estimation, what is at stake is not whether the Supreme Court can make policy or directives, but as to whether they are authorized to supplant the policy choices of the legislature. I hope you understand.
Can you repeat that?
Yeah, I'm just saying, for me, at stake is, we are not debating whether the judges of the Supreme Court can make rulings, but as to whether they are authorized to supplant the policy choices of the legislature. And I think that is what the legal gymnastics we've seen this weekend is all about. Everybody has expressed a very different opinion. But
is it more policy choices or the internal workings? Because if a policy choice of the legislature is unconstitutional, the Supreme Court, being the highest court of the land, vested with the power of interpreting the Constitution, you would assume, in fact, you can actually even ask the Supreme Court to overturn a decision of the president, because the constitutionality
of it
is what rule of law is about. So whether it's the judiciary, whether it's the legislature, so that's why you can go to Supreme Court to interpret something another court has done.
Yes.
So Supreme Court can say a lower court erred. A Supreme Court panel can review what its own policies did. So it stands to reason that being the highest court of the land and interpreter of the Constitution, if the president acts unconstitutionally or the Parliament acts unconstitutionally, the Supreme Court has a right to declare it so.
Yes, but that's what I'm saying, that is what we have here. And I would not say it's a unique situation in Ghana, but the conundrum or the problem is we've had too many instances where we've had.
So let me take a quick interview on this. I'll come back to you. So as I said, a lot of interviews. Mahama Yarga is MP for Boku Central, one of the leading legal lights of the NDC. We just want to understand the position of the NDC legally first, and then tactically what they are doing next. So Honorable Ayaraga, thanks for joining us, and I know you are very busy this morning, so let's just make it straight to the point. So on Thursday, we know that Speaker Bagbin made a ruling. Is it my understanding that for the NDC, that is the ruling that stands, that despite the stay of execution that the Supreme Court declared or issued on Friday, the minority's understanding, or the NDC's understanding, is that Speaker Bagbin's ruling stands? Is that how I should understand the position of the NDC in Parliament?
Yes, that's our position, that we will act according to Speaker Bagbin's communication until he communicates otherwise. So if what is said to have been done by the Supreme Court is served on Speaker Bagbin, and he comes to Parliament and communicates anything to us on the basis of what he has heard from the Supreme Court, we would act according to the communication given to us by Speaker Bagbin, because we are in a coordinate branch of government, which is the legislature. We listen to our Speaker. We don't listen to the Supreme Court. And in any case, we, the minority, were not, the minority at that time and now the majority, were not part of the proceedings, were not a party to the action in court, and the court hasn't spoken directly to us.
Will your view have been different if this was served on notice? So maybe on Friday they went and then you were served, and then on Monday you were to go to court to hear for the stay. Would this have been a different posture? Are you ignoring the Supreme Court because they went ex parte?
we are ignoring the Supreme Court because we are a coordinate branch of government. And the Constitution is very clear that the Supreme Court should not interfere in our work. We are protected by the Constitution. If you look at Article 115 of the Constitution and Article 122 of the Constitution, it protects the integrity of our proceedings and says that those proceedings should not be impeached or questioned in any court, including the Supreme Court. So it surprises us that the Supreme Court, which is supposed to be the body that understands the Constitution better than anybody, will see Article 115 and still go ahead to impeach our proceedings without even so much as, listening to the side of the Speaker and Parliament. So we would have taken the same position even if they had invited her. But if they had invited the Speaker, perhaps they would have benefited from all the arguments that today we are making. And many senior lawyers are making the same argument that, look, this is not a matter that even should have been entertained by the Supreme Court. This is a matter that should have started at the High Court because Article 99 is very clear on the subject that when it comes to a question of whether or not a seat is vacant, that is a matter that is reserved for the High Court. If there is some misunderstanding, the High Court can then stay proceedings and refer it to the Supreme Court. Then the Supreme Court can give the High Court guidance as to how to go about the matter. This is the structure of the Constitution. And we expect the Supreme Court to understand this. Maybe if it had said, look, let's not be in a hurry. Oh, today is Friday, there is Saturday, there is Sunday, there is Monday. The Parliament will not sit until Tuesday. So let's just invite them. Let's hear the urgency. What's so urgent about this matter that you are forcing us to act within 24 hours of your filing of an application? They would have benefited from superior wisdom. They have to be guided by lawyers. If you go and listen to one lawyer, you can easily be misled. And that is what has happened. They've been misled.
Some are saying that if the Speaker chooses to disregard or not abide by the Supreme Court's ruling, he essentially will be held accountable for what is called a high crime, quoting Article 2, 3 and Article 4, that he will be in contempt of the court. Do you understand this? Do you agree with this?
I think that we should wait and hear from the Speaker on Tuesday before we start speculating and saying all these things. Like I said, to tell you the truth, I have a problem with the understanding of some of these judges of our Constitution. If provisions as basic and clear as Article 97, 99, 115, 122, 130, if provisions as basic and as clear as these ones can be so gravely misconstrued by these judges, I don't know what they understand by the provisions that trigger high crime. I don't know whether they understand the provisions that relate to high crime. And of course, they haven't said this. You are the one saying that some have said. So I'm not sure any judge has said.
No, I'm just referring. Yeah, I'm just referring to.
It's just analysts. So I'm saying that I don't know if these analysts understand what really a high crime is. That I disagree. A coordinate branch of government disagrees with another coordinate branch of government that it is supposed to exercise supervisory authority on. People have forgotten that the legislature in some jurisdictions is actually the most supreme. In the UK, the legislature is almost sovereign. In Ghana, we tampered with the sovereignty of the legislature and limited it. So people should not forget that it is actually Parliament that has supervisory jurisdiction over the two other coordinate branches of government. That is why the powers of impeachment of both the legislature and the judiciary is given to Parliament. So we are supposed to be supervising them as well, in the same way that they're also supposed to be interpreting and enforcing the Constitution. So we are co-equals and coordinate branches of government. We are not a hierarchy where the Supreme Court is superior to the executive, to the legislature. No.
Okay.
We are not.
Finally, some people are saying we could be in a position where the speaker can also say the judges are in contempt of parliament. So that if the court says that the speaker is in contempt of court, parliament could also say that the court is in contempt of parliament, and we have a double contempt leading to a constitutional crisis. Now, as a constitutional lawyer yourself, how do we avoid this? I mean, you've explained the NDC position and you've told me what you will do tactically, but now I'm asking you a general question around this very possible constitutional crisis that if both sides, and by that I mean if the Speaker and the Supreme Court decide to hold entrenched positions, there will be obviously a constitutional crisis. How do we wriggle our way out of that?
We are a human society trying to regulate ourselves by writing down how we should regulate ourselves. We've written it down in the Constitution. Though you and I didn't write it, those who crafted it wrote it, and then we have accepted it and feel bound by it. The provisions in Article 122 on contempt of Parliament are very, very clear. That if you do anything that affronts the dignity of Parliament, and the Speaker, who is the one to interpret the rules of Parliament, and such conduct concludes that it is contempt, then it is contempt. The same way, the courts, by practice, have also developed contempt powers, where they feel that if you challenge their authority and you undermine their integrity and image, the same way the Constitution says they should also not undermine the integrity and image of the legislature, then you are in contempt. So both institutions have contempt power. But in the case of Parliament, it is expressly written into the Constitution as a protection for Parliament. If that arises, then I believe that it provides an excellent opportunity for the institutions, the coordinate institutions, to talk to each other. And when they talk to each other, they will resolve it, and they will learn from it, and tomorrow they will all behave properly. And let me conclude on this issue. It happened before. In the U.S., in the case of Baker and Carr in 1968, the U.S. Supreme Court learned its lessons and said, look, you know what? Don't get involved in politics. Don't get involved in matters that are the preserve of the coordinate branches of government. When a matter can lead to controversies like that, where one branch of government will say one thing and another branch of government will say another thing, please, Supreme Court, stay away from it. And that is what is called the political question doctrine. And this is a classic case of a political question that the Supreme Court should have just stayed away. Because if you read the proceedings of Parliament, of the Supreme Court, and the kind of things that the judges said, when you go to the section where it says by court, you see them saying, that there will be chaos in the country, that there will be stalling of government business in Parliament, that the budget may not be passed, that the NDC caucus will repeal certain laws, and that they intend to take certain actions to reconstitute the committees. These are all political matters that the Supreme Court should not be interested in. If the NDC in Parliament does that, and so what? Is that your business? Is that our business as a court? It's not our business. Go and deal with it as a political matter. If the electorate votes and then NDC is the majority in the Parliament, can we, the Supreme Court, sit in the court and start saying that no, don't block the minority government from passing a budget. Don't reverse legislation. Don't constitute committees. These are all political matters that are governed by the rules of Parliament. So in Baker and Carr, the Supreme Court said, look, Supreme Court, stay away from these matters because these are matters reserved for the politicians who constitute the executive and constitute the legislature. So we don't want to get involved. We will only get involved if there is a serious issue about what the words of the Constitution actually mean. We will just tell you what we think is the meaning and leave you. And then it's your responsibility to do whatever you want to do with our understanding of the meaning. That is all. But to jump in and start saying the things that the courts were saying, as if you are a branch of the MPP. Why are you foot soldiers? Why are you worried about whether the MPP is able to protect the e-levy law in Parliament? Why are you worried about whether or not they pass the budget? You've been watching CNN. Sometimes Congress cannot pass budget. The Supreme Court is sitting and watching them. How they pass the budget, they talk to each other. And finally, they come to a compromise. Then they remove the provisions that the Republicans don't want or add the arrangements that the Republicans want captured. then the Republicans come on board and they pass it for them. These are pure political matters that the Supreme Court shouldn't get involved in.
All right. I'll leave you now. Thank you, Honorable Ayarga. This is a fluid development. We'll talk again, I'm sure. Tomorrow will be an interesting day. Mahama Ayarga is MP for Boku Central, also one of the leading NDC lawyers on this matter. We'll bring you tech and social media trends. We'll go to the other side and also speak to a legal mind from there as we carefully delineate the key issues in this very interesting controversy. Now, the interesting thing is that for every article you see, in terms of, I'm not referring to article in the Constitution. I'm referring to article written. For every article you see criticizing the
Supreme Court,
the speaker, there's also an article defending.
Yeah.
So I'll give you a couple of examples.
Okay.
Now, there's one article that I have read over the weekend, written by Joseph Kweku Asamoah, PhD. And it's titled Review of Supreme Court's Ruling to Hold the Ruling of the Speaker of Parliament. Does it amount to an unconstitutional usurpation of parliamentary powers by the Supreme Court of Ghana?
Yeah.
Now, that's well written. Then there's another well written one.
By Justice Abdullahi.
No, before that, lawyer Idi Muhyiddin, open letter to the Speaker of Parliament on the current brouhaha in Parliament over his declaration of 4 seats vacant. So essentially, the Joseph Kweku Asamoah article is basically saying that he thinks the Supreme Court did an overreach by declaring or trying to influence the Speaker's ruling. Because they believe that the Supreme Court, even though it has the power to interpret the Constitution, overstepped its constitutional bounds. But that's his view.
Yeah, but so there are those who have even said, did the Speaker make a ruling or simply stated what had come to pass?
Good, but then there are also people say, do you make a ruling or whatever he did on a basis of a statement or a motion? So there's all kinds of things. So don't forget how we got here. Initially, Haruna Iddrisu had wanted to table a motion which would have been debated, but then a statement was rather put forward by the minority leader, which the Speaker then said he would give himself 2 days to come up with a judgment on. So I interviewed Apenyemaka and we discussed all of this. So this article is basically saying that he feels the Supreme Court overstepped their bounds. But this article is basically saying no, that the Constitution is the supreme law of the land. And if you look at chapter 1, and I'll read portions of that, a person who alleges that an enactment or anything contained or done under the authority of this or of any enactment or any act of omission or commission is inconsistent with or is in contravention of a provision of this Constitution may bring an action to the Supreme Court for declaration to that effect. Now it says, the Supreme Court shall, for the purpose of declaration under this clause, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to a declaration made. Now, this is the other part. Any person or groups of persons to whom an order or direction is addressed to under clause 2 of this article by the Supreme Court shall duly obey and carry out terms of the order. Now, 4 is where the issue is. Failure to carry out terms of an order or direction made or given under clause 2 of this article constitute a high crime under this Constitution. So basically, the Supreme Court Constitution is in chapter 1, and the Supreme Court is given the right and the power to interpret. Now you go to 122, where Parliament also cannot be obstructed in their line of duty, right? An act of a commission or an act of or omission which obstructs or impedes Parliament in the performance of its functions, or which obstructs or impedes a member of officer of Parliament in the discharge of their duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result is contempt of Parliament. So you have essentially 2 powers guaranteed: the Supreme Court to interpret the Constitution, Parliament to carry out its functions. Now you're in a situation where those powers are clashing. Let's speak to MP for Ebuakwa South and a lawyer, Atachia, on first his understanding of where we are with the matters, and then his own personal view on how to resolve this potential constitutional crisis. Honorable Atachia, good morning. Thanks for joining us.
Good morning.
Wonderful. So we in the media initially were even confused as to what to call each side, because what the chronology of events was that on Thursday the Speaker made a declaration which essentially said that 4 seats were vacant, and therefore by calculation the NDCs had a majority. Then on Friday the MPP went to court in Parliament, essentially got the Supreme Court to stay execution of what the Speaker had done. So as we sit today, we don't really know what stands, because the NDC is telling us that on Tuesday, when they go to Parliament, they are the majority, and that they will listen to what the Speaker says to them. The Speaker hasn't told us what he will do on Tuesday. Now, what do you make of all this? Where are we? Is what the Supreme Court is saying what holds, or does the Speaker have the latitude to make a decision as to what direction to go?
Yes, thank you very much. I'm sure a lot of people are coming to terms with the fact that we are under a constitutional rule. We are not practicing what they call legislative supremacy, where Parliament is supreme. So both the executive and the legislature function by the Constitution. In fact, the very space that the Speaker occupies is clearly delineated in the Constitution. So it is a Constitution that gave the Speaker the power to do whatever he is attempting to do. Now, if the decision of the Speaker violates the Constitution, or somebody is gone to court to say that, look, there is a necessity to interpret the Constitution, and the Speaker is not a judge to do so. The Speaker presides over the deliberations of the Parliament. How can somebody say that that decision from the Supreme Court has a clash with the ruling of the Speaker? In the first instance, a lot of people are thinking through this issue critically, that at a point somebody says is bringing a motion, then that translates into a statement. When you pay regard to outstanding orders, a statement of this nature should be referred to the appropriate committee for investigation and report. Now the Speaker also flouts the standing order and then says that I will give a ruling, and by that ruling, the ruling party becomes a minority. So what is happening is constitutional lawlessness, and some people want to profit from it. And I don't see how anybody will say that, well, I've not gone to the polls. There's no election, but by the fiat of the Speaker, I mean, I have the majority in Parliament. It's a chaotic situation that I believe that it's an affront to the legislature.
Fair enough. Now, without going back to all the issues that happened on Thursday, some people feel like what the Speaker did was natural, because according to the Constitution, a seat of a member of Parliament shall be declared vacant by the Speaker under Clause 1B and H and Article 97 of the Constitution, so that if the four make a decision to go and stand for another party or go independent, it is automatic. So the Speaker was only enforcing the law, and that this is within the parliamentary, how shall I say, this is parliamentary issues, administrative parliamentary issues that he's just implementing. So this isn't a constitutional matter that even requires interpretation. What do you say to that?
Who will decide whether it requires interpretation or doesn't require interpretation? Is it not the Supreme Court that will say that you brought to me a very bogus case to interpret? I've dismissed it. You see, when they measure themselves by themselves, according to the scriptures, they are not wise. How can you sit down and say that this does not require interpretation? Because in the information and the evidential support for the so-called Speaker's decision, it's not even certain. The people who say they've crossed carpet, you understand, are they thinking about the elections of December 7th and thereafter, which is to say their desire as to where they will go after the elections? Or they are talking about the term of this Parliament? I mean, did you call them?
No, that's fair enough. That's a fair point. The other point, though, people make is that if we are to wait for them to actually go into the next Parliament, then it means that provision about crossing carpet is moot. Because if somebody says, I'm going to run as an independent, even though I'm in NDC, and you're saying that only takes effect when he actually has gone into the election, then what's the point of having the issue about cross carpet? Because he couldn't have cross carpet in the next Parliament, right? I think this was part of the Speaker's ruling, the logic of his ruling, essentially that if we can't enforce it now, then it's a useless provision. This was his view.
You see, that view is warped on the ground that you need to cross carpet during the term that you are serving as a member of Parliament. That is what it is. You read the provision very well. It relates to the election that brought you there. It doesn't relate to a future election. You see, therefore, if you pay regard to Article 97 properly, it relates to matters of the election that ushered you into the chamber as a member of parliament. And now, let us also be very, very, very cocksure about it. As of now, the individuals who, by the stroke of the pen, have been disabled from functioning as members of parliament, were they heard? Is there anything that they put forward to the Speaker? Now, Mr. Speaker, this is what we've done, and therefore we invite you to make a determination.
So in essence, the idea of leaving your party, because it says, and permit me, 97G, if he leaves the party of which he was a member at the time of his election to parliament to join another party,
precisely,
or seeks to remain
of the election.
Hold on, let me finish. I'm just reading it. If he leaves the party of which he was a member at the time of his election to parliament to join another party, or seeks to remain in parliament as an independent member, so it makes reference to that parliament, to remain in that parliament. Now,
precisely.
Now hold on. And H, if he was elected a member of parliament as an independent candidate and joins a political party. Now, this is the contention, that once you have gone to, for example, the independent candidate for Esiama Fomena, he was elected as an independent candidate. In the next election, he will be a parliamentary candidate for the NPP. All right? And he cannot be a parliamentary candidate for the NPP if he has not joined the NPP. Because by the rules of NPP, you can't be a parliamentary candidate for a party if you are not a member of our party. Right? So, even though he's an independent member of parliament in this parliament, the fact that he has notified the EC and filed that he's going to be NPP candidate for Fomena for next election, is that not enough to say he has joined? Because your rules as NPP say you cannot be our candidate if you have not joined our party. So he has already triggered it. This is the view of Speaker.
It is warped. It's a non sequitur, because when you look at the fact situation, what are we addressing? Is it the now moment, or what he intends doing and it's even triggered it? We should look at it critically. If immediately you bring this kind of interpretation to bear Article 97, you want to say that a member of parliament is robotic and he cannot change his mind concerning what he wants to do in the future. So if you look at the intent of Article 97, it was addressing the now moment and not what somebody might want to do in the future. So right now, you are an independent candidate, and then you said you've crossed carpet.
Yeah, but joining another party.
For what purpose?
No,
for
but
the future.
No, yeah, but the Constitution doesn't talk about future. It just says if you join another party. And my question is that, is joining another party not clear that you cannot run for a party if you've not joined it? So my argument is that
for what purpose?
For a future election, but you have joined the party. So the operative word is joining the party, is it not?
Yes. You see, is joining the party is of no consequence to your current situation. If you intend that you will join the party for the next election.
I see. So your view is that the operative word is
which will sit. Yes.
Fair enough. Okay. Let's ask about 4 years ago, because people point to what the MPP did with the same Amwakwe Siama for Fomena when he had declared his intention to go as an independent, and the MPP wrote to Speaker Okwe to say this guy is not a member of our party because by showing his intention to go independent, he has forfeited the membership of the MPP, and Speaker Okwe obliged. All right. So was that also a warped interpretation?
I'm saying that even Speaker Okwe has assumed a role of a Supreme Court, and none of them has the power to do so. And the errors of yesterday should not have significance today. You see, the kind of banter we are having, it tells you that the Supreme Court should interpret whether it is a futuristic intention or it's a now moment. That is why a speaker cannot be an extension of the Supreme Court, with the greatest of respect. So the speaker, if you pay regard to Article 130 of the Constitution, even the courts, whenever there is the situation to interpret the Constitution, they should hold their hands and make a reference to the forum defined by the very Constitution that gave the Speaker the space to function as a Speaker, to do the interpretation. When you say that the legislature can now do interpretation of the Supreme Court, the Constitution will be sitting.
So you are saying Okwe was wrong in 2020.
Whatever Okwe did, you understand? I'm saying that he couldn't interpret the Constitution. If he was interpreting the Constitution, he was wrong, because he cannot. And let me also warn you about how we believe that, let's go and find something which was yesterday to suit the 9 moments. If Okwe was wrong in interpreting the Constitution, would it be right for Speaker Bagwin to interpret the Constitution? Both of them will be wrong.
Well, I'm not a lawyer, but what we are told, what you lawyers tell us is that if you want to understand something, you lose the statute, legal precedent, or best practice. So there is a space for precedent, right? We are not talking about the past. If somebody has done something, so it's not necessarily like fishing from the past.
You are talking about stare decisis, but let me tell you, the Speaker is not bound by the previous decision. He can depart from it. That is what it is.
Fair enough. I'm just saying that. So you see, I'm trying to get people to understand the various aspects. So I'm not really arguing. I just want to understand that if somebody pulls something from the past as legal precedent, which you are saying, you are saying that it can be applied. But if there's contention over its meaning, we can go to Supreme Court to say, is this the right interpretation? That's what you are trying to say.
Of course. I'm saying that both of them, the old Speaker and the current one, they can't assume the role of the Constitution in terms of the interpretation of the Constitution. That is what it is. So when you go into this post-mortem of trying to say that, well, Speaker Bagman did it, so that I should also did it. Will 2 wrongs make 1 right? I'm telling you, none of them has the power to interpret the Constitution. And this conversation, I'm very glad you understand the issues critically. The conversation we are having is indicative of the fact that, indeed and in fact, the Supreme Court has something to pronounce on the matter.
Good.
So even when you had the benefit of an information that something has been filed relating to what we're trying to determine, and then also there's an injunction to boot, and then you sit as a Speaker and ignore all these issues and come out with this decision. Is it not constitutional lawlessness? Okay.
Some people say stay of execution from their legal experience is not something you ask a Supreme Court to do. And usually you only stay the decision of a court. The Speaker is not a court, right? Speaker made, I don't know what to call it, but it's within a parliamentary space. So for them, it's quite curious that a Supreme Court would grant a stay of execution of what essentially is a parliamentary order. Number one. Number two, they also worry about why this was done ex parte. That if you wanted to really get this properly dealt with, you should have gone on notice. Maybe the Supreme Court would have given both parties the chance today, Monday, because Parliament is coming back on Tuesday, and this was Friday, so that if you wanted to also show that you wanted to give both sides a hearing, both the Speaker and then the people who felt aggrieved, you should have gone on notice instead of going ex parte on Friday to then basically seek to stay what the Speaker has done. What are your thoughts on those two angles?
In the first instance, what the Speaker did, if it violates the Constitution, what you read to the general public in terms of the interpretative power of they can make further orders. You just read it to the whole Ghana to listen. The Supreme Court is not sitting down as an academic chamber that they will not give efficacy to what matters. Now let me ask you this question: what the Speaker did, has it gotten any consequences? Sure, it means that some actions. The decision will bring some consequences. That there is now a majority turned into a minority and the rest of it. Therefore, if anybody said that, the Supreme Court should just fold its arm and not do anything about it, then they don't understand the full import of the powers of the Supreme Court. Because anything that has a consequence and touches on the Constitution, the Supreme Court can act on it. So the very provision you read this morning. If what the Speaker did is useless, why is NDC taking advantage of it? It is unfortunate. It is very, very unfortunate that people want to give this poor interpretation to what has happened in Parliament. What has happened in Parliament has consequences. And it is something that another party is taking the benefit. If it is just brutal filming, why are they running after it? That they are very excited. Their flag bearer is also excited about it. That look, now we have the majority. We are going to even overturn the E-levy and the rest of the rantings that are going on. So you think if it is a zero, decision, a decision of void consequences, people will be running after it. So let's get another.
What about the ex parte part of my question? The fact that
it is part of the justice delivery system. In emergencies, you can always go ex parte because the process of getting somebody said it's a very difficult process. If you didn't find the person, then your case will be in a mess. So you can go ex parte, and then the one who is affected by the decision of the ex parte ruling or order can come back to the court to set it aside, or they can order you to come after some time on notice and serve the person, so that there will not be anything like a fluid situation where people will not have remedy. So, because of the pleasure of NDC, ex parte applications are not important, and they should really have.
So, as you rightly pointed out, I read out Chapter 1, Article 1, 2, and I did 2, 3, and 4, which talks about the supremacy of the Constitution and the Supreme Court being the appropriate body to interpret this. But some people also point to Article 122, where Parliament also should not be obstructed or impeded in the performance of its functions. Now, if Speaker Bagbin tomorrow morning construes what he did on Thursday as performance of his function and sees what the Supreme Court did on Friday as an attempt to impede his work, can we not be in a difficult position? Because from what I read earlier from Chapter 1, if the Speaker fails to carry out what Parliament did, what the Supreme Court put out, he could be in contempt of the court, right? But some are pointing out to 122 that, well, he could also say, I am performing my role as Speaker for Parliament, and the court should not impede us. So then we would have two types of contempt. He could even say, well, we are writing to the President to cite the court for trying to contempt Parliament, right? It may sound absurd, but it's a possibility, is it not? And if that happens, where do we go?
Well, if you look at Article 122, where is it you are trying to impede the work of Parliament? Where is it written that Parliament should be an extension of the Supreme Court and interpret the Constitution? So when a speaker is being lawless, you say that somebody is trying to obstruct him in the performance of his duty. I mean, do we understand what we are saying? That we have what, because of Article 122, we have what we call legislative interpretation of the Constitution. Is the legislature given any power to interpret the Constitution? And do we have legislative supremacy under this Constitution, or we have constitutional supremacy that the Constitution even determines the powers of the President, the executive? So why would anybody say that, now what the Speaker does is sacrosanct? It can't be questioned by the Supreme Court. That is an absurdity of the highest order.
Now, Mr. Atachan, this Parliament has had at least 2 or 3 instances where things done in Parliament have gone to the Supreme Court. So, for example, on the matter of whether a Speaker sitting, a Deputy Speaker sitting can vote, I remember it became a Supreme Court matter. LGBTQ transmission of the bill to President has also gone to the Supreme Court, and now we have this. As an experienced legislator, is this good for our democracy or is it worrying?
It's very good for our democracy. That is why there will always be issues and tussles relating to meaning and understanding of the Constitution. And the very Constitution which gave the Speaker the space to sit where we are sitting, and all the members of Parliament, they didn't come there because of their good looks. They came there on the strength of the Constitution. The Constitution giving space that you should go for a parliamentary election. And when you succeed and the EC declares you as the winner, then you come to the Parliament and you are sworn in. So what we are doing is a constitutional arrangement. And we should respect the Constitution. So if there is a misunderstanding as to whether somebody can vote and is a member of Parliament and a second deputy speaker, whatever, who should interpret that? I told you something in the Bible. I can't find the verse. But it says that when they measure themselves by themselves, then they are not wise. If the legislature is now the Supreme Court and is doing stuff and thinking that, okay, I will sanction the rightness of my own actions. So what is the meaning of, constitutional democracy? So where is the constitution in this matter?
But
so
Honorable, to the extent that almost everything you do in that parliament is guided by standing orders and must be constitutional, we could get to a point where almost every action will be legislated, will be taken to court. Could be, right? Because we've also been told in the past that Parliament is also a master of its own procedures, so it can adopt conventions and procedures to the extent that they feel that those procedures help it to come up with their functions. But if we are to go on the tangent of this constitutionality, and of course I'm not against constitutionality, does that not reduce the ability of Parliament to function, where almost every action will be hamstrung by a court interpretation? Because everything they do is they are trying to interpret their standing orders and they are trying to basically adhere to the Constitution. So almost everything they do there, the court will have to decide then eventually.
It is not. It's only when we have dubious interpretations that will happen. Since we came to Parliament, you've just said that there has only been two. It is only when the Parliament decides to list its boundaries properly defined in a decent way by the Constitution and assume roles that have not been assigned it by the very Constitution, then we'll have challenges. It is not true. Look at when it started, even 1992, J.J. Rawlins's time to date. How many times have we gone to Parliament and said that we are trying to stop the work of Parliament? Has the Supreme Court ever said it will stop the work of Parliament? It will only sanitize what is right by Parliament through what we call constitutional interpretation. That is all. The Supreme Court is not interested in, micromanaging Parliament. It's not doing that at all. And let's get it right.
So if the law is clear, you apply it. If the law is not clear, you go for interpretation. Basically, that's what it is, right?
That is what it is. You see, if there is no, issue or any matter of controversy, what are you interpreting? But there's a matter of controversy. Even now, I'm so excited that you understand the parameters of, what is happening. That you are talking about the fact that whether it relates to the election or it is a future decision, and I'm telling you the truth, the banter we are having now, it's like as if we are in the Supreme Court arguing, and they will have the remedy. They are the referee, you see, to look at, the Constitution and say that, yes, okay, my brother speaking to Atatia, I think the superior argument is with you, and these are reasons why we should uphold your submission. That is the sanity of the Constitution. The Constitution is not saying that set your own marks and then set your own exam and then mark it. You understand? Then you have a legislature trying to do the law, the work of the court, and somebody who is very mischievous is saying that, in terms of Article 122, the Supreme Court is trying to interfere with our work and hamstring us. It doesn't accord with common sense.
So what do you expect to happen on Tuesday So, by the way, will you go to Parliament on Tuesday? Because on Thursday, the leader said that the MPP will not go to Parliament until the matter is heard. But that was before the stay of execution was granted. So, what is the strategy? Is MPP going to be in Parliament on Tuesday?
I don't have the collective strategy, and it will lie ill in my mouth to begin to pontificate as to what we'll do. So I think it's a leadership thing together with all of us. The quality decision will be taken probably today, which is a non-sitting day, and then we know the way forward. But I'm saying that MPP will not promote constitutional lawlessness. We are not going to do that. It is wrong for anybody to say that in the name of Parliament, let me be lawless. No, if you don't respect the Constitution, then you are not entitled to sit as a member of Parliament. Because it is the very Constitution that gave you the space to sit as a member of Parliament. If you believe in lawlessness, please, then you don't understand the rule of law. And it's a disgrace to your honor as a member of Parliament to misbehave. That we will not abide the outcomes of judicial decisions. Then what are we trying to do?
Thank you for
all the people in Ghana say the cause do not matter. Excuse me to say, we are all reduced to savages and we are in the wild where your might and how you feel should prevail, not the rule of law. we should understand the rule of law. We are too old to ignore the rule of law. 1992 to date, we should come to terms with the rule of law and stop this, instinctive and whimsical postures, which at the end of the day is not healthy for us.
Thank you for talking to us, Honorable Atachia. We appreciate your time, sir.
My pleasure as always.
That was the MP for Ibuakwa South and lawyer Atachia, former minister.
Another interesting perspective.
You know, the thing, there are two sides to everything. Nathan said something this morning. He said there are two things.
There are two things involved.
He was quoting basketball. He said in life there are two things involved. You are either a man or a woman.
Man, there are two things. So in this matter,
there are two things
involved. It's either you go with the Supreme Court's ruling or you want to go the other.
But Bernard, in all this, let me tell you something. You know what I gleaned from all this? My take from this. Read that.
Is it 122?
Yes, the part that talks about how you can be removed from.
97.
Yes, how you can lose your seat. I think that at the end of all this, when this comes to an end, they might need to sit down to look at that particular clause.
They maybe have to declare that.
They have to declare, because you see, there is, looking at the interpretation that have been put to it and the meanings, there is no way that clause can effectively
be implemented. It will probably not survive.
It is a useless clause as it is.
Or maybe the Supreme Court will uphold what Babin did.
Whichever way.
If they did, then that makes it clear.
No, but because if you read it on the surface, you've read it several times. I've read it several times. It is pretty clear.
But you see, listen to Atachia, what I gleaned was my summary for him, which he agreed with.
Yes.
If the law is clear, enforce it. If the law is not clear, go for interpretation. You know why? It becomes unclear when it becomes contentious. So you see, for example, on the issue of whether a speaker, is this my phone?
Yes, it is.
Forgive me. Oh. When a speaker of a parliament, maybe the deputy speaker is sitting as the speaker, can he vote? I think there was some lack of clarity there, and so somebody took the matter to court. You remember that issue?
Yes.
Good. So I'm not sure whether controversy equates to content, or let me put it this way: the fact that a thing is contested or controversial, does it make it unclear? Do you see my logic? So when you read the 97, to the average reader, it's very clear,
which is what the law is supposed to be.
Good. Now, his argument is that you can't interpret it because it's gotten to a point of contention, and it's controversial because now somebody disagrees with the way you've interpreted it. So a clause becomes contentious and therefore controversial. Therefore, you have to go for interpretation and not just enforce it based on your understanding, because he calls it a warped interpretation. Do you follow me? So when I listen to Ayariga's point is that it's a clear law.
Yeah,
so you are just implementing.
But in listening to Lawyer Atachia,
yes,
and his explanation of that particular article as compared to what he called the warped interpretation, because his interpretation of it seeks to place this in the next parliament.
Yes,
which is not available here.
That's what Speaker said. Speaker said, if I'm going to look at next parliament, then this is useless.
Yes, because there is no way the spirit of this law
will say that
you have to deal with this. You have to look at a future election,
exactly,
or a future parliament.
Yes.
Then the people who wrote the law, I'm sorry, what was the thinking behind it?
It's a very interesting angle you've taken, and some people take your view as well. And indeed, when you read the Speaker's ruling,
there's no way the spirit of the law,
if he's going to wait for next year, and the other,
then it will not have existed like this.
And the other point that came to me, but I didn't raise in the interview,
I find it interesting. I think that clause, if whatever, they should look at it again.
And recall my question to him as well. I was trying to get his view around the automaticity of your losing
of
your
being
seat.
Triggered.
All right. So we said in 2020, Esiama is MPP MP.
Yeah,
then he says you go independent.
Yeah.
Now MPP rise to Speaker Okwe and said, per our constitution, Article 391 of the Constitution, a member of Parliament who decides to essentially run on another party's ticket automatically forfeits their membership. So that seems to satisfy the prerequisites for the Speaker to sack the person.
Sack the person, yes.
All right. So now that MPP is saying that what Speaker Babin is doing is unconstitutional, are they saying that their own constitution has a clause which is unconstitutional? Do you understand my logic? Because when you go to MPP constitution, once you go and run on another party's ticket or as independent, as an MPP member or vice versa, you automatically forfeit your membership, which then gives the speaker the right to do what he did. So if you're saying that what the speaker did is wrong, then it means that what you have also put in your party constitution is unconstitutional.
Yes. But
did you follow my point?
Yeah.
But of course, I didn't raise it, but I thought that it was an interesting angle too. So if the parliament, if the judiciary decides that the way the speaker has interpreted the law is unconstitutional, it may also mean that some clauses of the parties, and this is plural, political parties' constitutions are also unconstitutional.
So, for instance, my good friend Edin Tim sends a message who says that he thinks that there has to be an express statement of defection to trigger this.
Good. From who? The party, the person,
whichever. But those who also argue against that say, they are telling you that some of the things are express in the sense that you cannot say you are an independent candidate after being a member of party A or party B. Sit with that group in parliament.
Yeah.
But you are in the constituency campaigning against the interest of that.
Especially when the notice of poll is printed. Or it was evidence that you are filed.
You are filed.
So that filing is an action.
Is an action.
So do you work with EC, the party, or your own declaration? So what does that express thing mean? So maybe that's why they need a Supreme Court.
Wow.
So as I said, there are two good articles on this. So you can read Idi Muhayadin's article, which supports the MPP view, and then you can read and probably I need to share both, by the way.
Yeah, you have. People should find out. So they are online. They are available online.
The other article, I don't just want to give you the name of the author again. So this article is an open letter to the speaker. All right. The other article is written. I want the name of the guy. Give me 2 seconds. And he is interesting because he does it like an academic piece.
Yes.
But it came out only over the weekend.
Yes.
Right. So
that's Dr. Asamoah's piece.
Yes, that's the name, Dr. Asamoah. I'm trying to find it. I don't know where I put it. Just a minute. So yeah, get those two articles and read, and then you can decide what you believe. Yes, it's called Joseph Kweku Asamoah. So Joseph Kweku Asamoah's article thinks that the Supreme Court went overboard, but Idi's article thinks that the speaker went overboard. So
tomorrow is a new day.
There are a few voices I'm going to air on this. We've spoken to some people about what all of these things mean for our democracy. We'll bring you some highlights shortly. But Dr. Rashid Dramani is with the Africa Parliamentary Center. Now that we have this potential standoff between Parliament and the court, the Supreme Court, Speaker has made a judgment or a ruling. The Supreme Court has granted a stay of execution, and they didn't even give it a 10-day limit. They basically said, stay this until the matter is fully determined. And they went ex parte, the side that took the matter to court. Tuesday is going to be a very, very, very interesting day for people who are very concerned about health and importance of our parliaments. What do they think? Doc, thanks for joining us. Good morning. So,
good morning.
First and foremost, because you are with Africa Parliamentary Center,
it's African Center for Parliamentary Affairs.
Thank you,
Bernard.
Thank you.
Let me just
Africa Center for Parliamentary Affairs. Forgive me, a lot of
you
things.
You are one of our associates.
I know a lot of things in my head. So you exist to ensure that parliaments across the continent are strong and healthy as part of a well-functioning democracy, I presume. I want to understand how you see the importance of legislatures across the continent before I even come to my substantive question.
Bernard, I've been in parliamentary work since I finished my PhD. That's all I have done for more than 20 years now. And what many people sometimes fail to realize is that there are so many things that a parliament can do. And very few things that a parliament cannot do. And secondly, when you talk about a democratic system, the fulcrum is Parliament. So that is how important a Parliament and parliamentarians are in the scheme of things when we talk about a democratic dispensation.
Wonderful.
Yeah.
Now, this where we are today seems to be a matter where a ruling of a speaker is being questioned by one side and has been taken to court for interpretation. But while that matter will be interpreted, there's...
Sorry, Bernard, the line, got fuzzy a bit. I didn't hear.
So what I'm saying is that we have a misunderstanding over the speaker's ruling on Thursday, and one side of the House has gone to the Supreme Court to stay the execution of that ruling until a final determination of a substantive constitutional interpretation issue. Generally speaking, when things from Parliament are sent to the Supreme Court, should we be concerned? Because there's a view that parliaments are masters of their own rules, and their work should not be interfered with by any other arm of government. And yet some people say, well, you need to have the supremacy of the Constitution, and the person who has to interpret the Constitution is the judiciary. So where do you stand in that balance? How do we strike the right balance?
Well, I think, so let me say, Bernard, that, in even very older and well-established democracies, judicial reviews of, the workings of Parliament are accepted, but they are very rare. They are very, very rare because, the democratic architecture in almost every country is such that, the independence and the autonomy, of course, that doesn't suggest the absence of interdependence of the three branches of government is usually very well protected, so that the court would come in very rare circumstances when things are not very clear and the reading of Parliament of a constitutional provision is different from maybe the way that the court reads that provision. Under those kind of rare circumstances, the courts are called in to intervene and say, this is our reading of a particular provision, and that puts the matter to rest because, the Supreme Court is supposed to be the final say. I'm not a lawyer, but I think that that's what it is when it comes to matters law. So
these things are supposed to be rare.
So they are supposed to be rare, Bernard, but let me make a point that in this element, which has had so many different lives, and which has been characterized by any kind of dramas, we've seen a penchant for, members of Parliament, and sometimes members instigate, outside stakeholders to run to the court. And I've been telling them, what you are doing is you are weakening your own institution. Because wherever you find yourself today, it's not a permanent station. Because in parliamentary parlance, we say minorities change. And in our country, we know that we ought to be very careful how many times and how quick we run to the court to say, interpret or get involved in what we are trying to do to hold the executive to account. Just because maybe it doesn't please somebody or because, whatever is going on is something that somebody doesn't like. But they are forgetting that precedents are being set.
Yeah.
And tomorrow somebody will just get up and say, well, this happened. And that's what we have right now. People are saying, 4 years ago, this thing happened. Nobody went to court. So I'm talking about the precedent kind of aspect of it. And they are setting so many bad precedents that if we are not careful, we'll wake up someday and our parliament will be paralyzed.
Well, where we are today, depending on what happens tomorrow, we could have a standoff between two arms of government.
Yes.
What would that mean for our democracy? Because if the speaker decides to abide by Thursday's ruling and defy the court, some people think that means that he would have been in contempt of court. There are also those who say that the Parliament of Ghana cannot be obstructed in its work. They quote Article 122, and anybody who tries to do that will be contempt of Parliament. So we seem to be in a serious interpose, and I'm not sure if the executive can solve this, because of course they would not necessarily be seen to be neutral, right? How do we wriggle our way out of this in order not to compromise our democracy?
So, Bernard, yesterday I had your own platform. I granted an interview, and my view on this matter, I think, is that we need a conversation, a three-way conversation between the president, the speaker, and the chief justice. Anybody who thinks that this matter is going to resolve itself or things will play out, in the end, nothing is going to happen, I think they have to think again. Because we've seen instances in this 8th Parliament where both sides have dug in. So much so that, at some point in the history of this Parliament, things were almost breaking down. Some of us were involved in a lot of conversations and so on that brought the leaders together just to avoid, complete breakdown. But, those matters were not weighty and as serious as what we are dealing with right now. So you have a parliament today, we can say a parliament that has two majorities, each aiming to hold a majority position. And we are hearing, at least I heard from the majority, NDC whip, because I don't want to offend anybody by calling somebody majority, somebody minority, saying, heard that the military is going to come in. So apart from, Bernard, that the fact that our country could be plunged into a constitutional crisis and our democracy will be tested more than it has.
Hello? Hello? We seem to be having challenges with Dr. Dramani. We'll try and put him back on. He was making an important point. It's 19 minutes past 9. There are many possibilities for tomorrow, aren't there?
Yes, I was just playing around with a few in my head. So what if tomorrow the speaker calls Cynthia Morrison and asks her on the floor, which party are you contesting the election? Secretary, are you contesting the election? And she says, I'm going independent. Would that be considered an open declaration?
I think some people will say the question should be, which party are you a member of?
Yeah.
But again, by filing independent, you have automatically forfeited your membership of the MPP, according to what the MPP says.
Wouldn't that be the open declaration they are looking for?
It's difficult. Yeah, Dr. Daman, you were making an important point before we lost you. If you could just wrap up.
So, Bernard, I was saying that, apart from the fact that, this, the fourth Republican dispensation will be tested more than it has ever been since we started in 1993. Today the democracies are not don't have a lot of favor with the citizens across the globe. In our own country here, you look at Afrobarometer data. You go around the globe, there are so many reports that indicate that people don't have very fast losing faith in democracy and the processes of democracy itself. So our country is right now, if I say this, I'm not saying anything new. An island in a sub-region that is chaotic and all kind of issues. People are holding up very little hope about democracy, just using the examples of countries like ours. You have a crisis like this, it just reinforces, the views and sometimes the perceptions that people have. And so for me, that's because this has the potential to drag our entire sub-region into, something that we cannot recognize. Nigeria is facing its own crisis. Our Sahel brothers, that one, we can't even talk about that. Senegal is facing its own of how that has been resolved. But right now, there's even a test in that country. President dissolved parliament, they are going to elections. We don't know what's going to happen. So we don't want a situation where, all the good examples disappear. And with the leadership of Ghana, sometimes we go out there and people ask us, is it true that the military were in your parliament on the first day of the 8th parliament? And that alone is a big shame, Bernard. I think the point I'm making is that we have come along, and this is a time when we need to hear from the elders in this country, the imams, the archbishops, the chiefs, the peace council, and anybody who has the moral compass. I think we need to hear from them. If they wait until tomorrow and think that, we are capable of, to the extent that it is capable of resolving some of these difficulties, because this is a test case. So, all to say, it's a trying moment, and let us not wait until the horses have bolted before we see, a lot of movement. I was talking to some senior people this morning, and I said, look, whoever you can call, even if you have to call the office of the president, please do call, because we are joking with this matter, and I think that perhaps many people are not appreciating the weighty nature and the kind of consequences that tomorrow can bring to our nation and our image and our democracy.
Thank you very much, Dr. Rashid Dramani, for talking to us. He's from the Africa Center for Parliamentary Affairs. Time check, 9:24. We're still on the City Breakfast Show. We'll read some of your comments shortly. But yes, Mums is finally here. The news we've all been waiting for. Your favorite Cerelac now comes in a new variant with the combined goodness of wheat and maize, grains fortified with iron, vitamins, and minerals. And guess what? This new Cerelac wheat and maize comes at an affordable price of only 2 Ghana cedis per sachet. To prepare for this new Cerelac wheat and milk, just add milk. In fact, Cerelac, milk. Cerelac, care for them, count on us. This advert is FDA approved. All right, let's read some comments on this.
Yeah, it says, Godfred, it is not a policy choice. This is an interpretation of a process and procedure on how things should be done. Parliament doesn't occupy that space, irrespective of what has been done in the past. Bernard and team, beyond the legal jargon and self-serving interpretation, I think the Speaker's ruling should stand, since Parliament applied same in 2020 without anyone contesting it. Parliament should handle its own matters following its rules, while the Supreme Court continues to interpret the constitutional provision of MPs vacating their seats. Any interference in parliamentary proceedings to await somebody else's opinion gives the impression of bias towards one party, which is not a good precedent. Remember the golden rule. This is Courage from Kofodia. There will be even more confusion in Ghana's parliament, even into the first quarter of 2025. Time and again, God has sent several warnings to the Parliament of Ghana to serve the interests of the Ghanaian people, and they refused. The confusion will continue. Mark my words. Good morning, CBS.
Morning.
Please, my take on happening in Parliament is that someone can pretend to be with a political party just to win a seat in a stronghold of a party and then switch to the party of his choice if we don't deal with this issue properly. That is George. Alex Duane in London says constitutional crisis and it's sad. Our judiciary is too predictable. And this Ni Ado from Amman Firm says, hi Bernard team.
Hi.
And all this, who is thinking about the constituents who voted for these MPs to represent them for 4 years? Good morning, CBS team.
Morning.
I believe the Supreme Court has the ultimate power in interpreting the Constitution of Ghana. The Speaker gave a perceptive determination Parliament had to adhere. The MPs who lost their seats are not coming to the next Parliament. Should they be excused from Parliament? This gives a clear understanding to the current position of the Supreme Court. I believe it's common law that the MP's decision shall affect the next Parliament, but not the current. Fred Owari from DSL. Good morning, Bernard.
Morning.
Please ask Atacha what is his understanding of Article 34, Clause 1, the implementation of directive principle. Hello, City FM. A strong team of City FM. Hey, Charlie. My name is Mishael from Hohoi. It is obvious that these politicians are people of deception. The funny thing about this interpretation thing is that our politicians and the judiciary are telling us is that when I meet a policeman by the roadside and who is trying to apply the law of the land, I can be able to tell him that enforcement should wait until I go to court for interpretation. that's not that simple. Mishael, you lie, man. Interesting that Article 122 has come into play. Who has the power to even determine whether or not something amounts to contempt under Article 122? Parliament or the Supreme Court? Bernard, I felt sad listening to Lawyer Tachia. Why do we have separation of powers? You don't need to be a lawyer to read English text and understand it. You need to be a lawyer to process it. Good morning, Bernard and team.
Morning.
Assuming without admitting, because I'm not a lawyer, that Speaker Okwe was wrong, can there be any action against the state? Afote from Oyarefa. Mampong, Aria from Mampong says, good morning, Bernard.
Morning.
Can you call a non-partisan person to ask the question? I think that was, he did the interview in stages, so I'm sure.
So I did NDC, I did MPP, and then I did Draman. So yes. I hope that helps.
Bernardino, please. Why should he think the law seeking someone to vacate his or her seat is a futuristic one, while the person hasn't even won the future seat? They just lack principles. Vincent McAfee. Good morning, Bernard.
Morning.
Please ask. This one's was an Atachian question. What's the difference between applying the law and interpreting the law? Why didn't Atachian make this argument in 2020? But the students think we are dumb. When it's used, you make argument for it, and when it doesn't, you make arguments against. This country is at its worst. Politicians will clearly not save this country for the benefit of the masses, but only their own interest. This is surprisingly surprising. Kay says so. Kwesi Akwa from Sakumono. Please ask the lawyers this question for me. The Speaker has the notice of poll from the EC. If we go by the NPP's position, it means the parties are fielding 2 candidates per constituency. One is independent and the other is on their candidate. What does the electoral law say about multiple candidates by a political party? And this is, you see, this is what I've been saying, Bernard. Bottom line, this is the common man's interpretation of this law, this clause that is at the Supreme Court.
Yeah.
This is, let me read because I like it. Personally, I like it. I'll read it again. Charlie, Abeku, bring the thing again. Let me read it.
Kwesi Akwa from Sakumono.
Says, if the Speaker has the notice of poll from the EC, if we go by the MPP's position, it means the parties are fielding 2 candidates per constituency. One is independent and the other one is their party's candidate. What does the electoral law say about multiple candidates by a political party?
That is the question.
Bernard, please find out from the MP. Okay, that's.
So some of them are questions, right?
Yes. That's,
right.
Yeah. Thank you.
Okay. As for tomorrow, only God, Nathan. As for tomorrow.
Yep.
Let's read a few comments.
More drama. This one says, what hurts me is that this majority-minority issue is taking attention from the Galamsey campaign. I wish all these politicians talking left, right, center would do same or did same during the illegal mining campaign. Which Ghana are they fighting for?
Say again.
This one says, can you seek the view of any former Supreme Court judge, preferably, his Justice Atuguba or Justice Gloria Kufu?
Okay.
Max from Adenta is asking. We'll see if we can do that. Please, the speaker's rule should stand. Why do we have separation of powers? Raw from Showman.
Okay.
And I agree with Dr. Dramani. The issue at hand is weightier than we think.
Yeah.
That's from the business scientist.
It's a very grave matter which I think requires cool heads. We don't need... we don't allow the hawks to always push us to the brink. We're in a difficult situation. We have 2 months to an election. We want the election to be peaceful, and then whatever happens after that will also be peaceful. So some of these build-ups, and you see, this parliament has had a very checkered history. The way it even was, how do I even put it, brought into being. Yeah. It was birthed in anarchy. Voting and all the people chewing ballots, chasing. So it's I don't know.
Remember when we were dealing with, there was a time I told you we need, when the OSP was having issues, we need, my suggestion was the OSP should try and have a conversation with the Chief Justice, because there is no way the OSP's job can be done without the judiciary. Yeah. And he must make certain things clear to the Chief Justice that this is what we need to do.
Yeah.
And Dr. Draman also makes the important point that, look, there should be a conversation between the CJ, the Speaker, perhaps even the President, if need be, on some of these matters to understand and get on the same page. Because, like you're saying, sometimes the repercussions goes beyond your party interests. Okay, so if they're able to have conversations about these things, they're better for us and democracy. But if we want to always do it like this, well,
it's not going to help us.
It's not going to help us.